Jefferson County Court at Law number 2 is back in session. The court is in session with cause number 26 CCCR 1076. Case of style of state of Texas versus Jose Miguel Delgado. Mr. Delgado, is that your full name? Mr. Delgado, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Delgado, you may put your hand down. How are you doing, Mr. Delgado? You doing well? That's good. Mr. Delgado, I'm doing fine. The state is represented in this case by Attorney Samuel Masradian. Attorney Masradian, how are you doing?
I'm doing well, Judge. Thank you.
You're welcome. Now, Mr. Delgado, your attorney record is Attorney Todd Takash. Attorney Takash is not here today. However, standing in for Attorney Takash is Attorney Sean Head. Does Attorney Head have your permission to stand in for Attorney Takash? And again, Mr. Head, how are you doing?
Good, Judge.
Okay, and Mr. Head, do you waive a record in Mr. Delgado's case?
Yes.
Mr. Delgado, I have before me on my computer a document that is titled complaint. This complaint was filed by the city of Port Arthur. And it alleges in this complaint that on or about December 10th of 2024, while you in the city of Port Arthur in Jefferson County, Texas, that you committed the Class C misdemeanor offense of failure to your right of way. Mr. Delgado, do you understand what you have been charged with? And to this charge, Mr. Delgado, how do you plead? Not guilty, guilty, or no contest? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? You pleading guilty because you are guilty?
Yeah.
Okay, now, Mr. Delgado, I also have before me a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials, JD, on a line next to a box that's checked guilty. Did you place your initials on this document? Yes, on page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document. And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Mr. Delgado, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. Delgado, are you a citizen of the United States?
Sorry. State offer States Exhibit 1, Your Honor. No objection.
No objection. States Exhibit Number 1 will be admitted. And Mr. Head, you advised and counseled Mr. Delgado. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Delgado, are you satisfied with the services of Attorney Head? And are you also satisfied with the services of Attorney Takash? Okay. Now, Mr. Delgado, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
Be a fine of $100 plus court costs.
Okay. Okay, what is the court cost in this case? Okay, Mr. Delgado, the state is offering that you pay a fine of $100 plus court costs of $277, which comes to a total of $377. And will you be able to pay that? Okay. Now, Mr. Delgado, do you understand the state's offer? And do you accept the state's offer? Okay, Mr. Delgado, I'll follow the plea bargain agreement that you have entered into today. Mr. Delgado, you'll stand next to the bailiff follow her directions. Once you finish following her directions, you can go downstairs to the county clerk's office, make the payment. Once you make the payment, you can come back upstairs with the receipt. Okay? All right, please stand next to the bailiff.
Thank you.
You're welcome. Mr. Head, you're free to go. Let the record reflect that the court is back in session in cause number 23 CCCR 0951, case of South State of Texas versus Trevani Slaughter. Let the record reflect that Mr. Slaughter is present in court with his attorney Tom Burbank. Let the record reflect that the state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon and Attorney Samuel Masradian. And let the record also reflect that the jury is now present and seated in the courtroom. State, are you ready?
Yes, Your Honor.
Okay. Defense, are you ready?
Yes, sir.
Okay. At this time, ladies and gentlemen, I will read to you the court's charge. And just before I read the charge, I'll just reiterate that on yesterday, both the state and the defense rested their cases. Now, members of the jury, the defendant Trevani Slaughter stands charged with the offense of resisting arrest alleged to have been committed in Jefferson County, Texas, on or about the 12th day of February 2023. To this charge, the defendant has entered a plea of not guilty. A person commits the offense if he intentionally prevents or obstructs a person he knows is a peace officer from effecting an arrest of the actor by using force against the peace officer. It is no defense that the arrest was unlawful. So that you may better understand the nature of the offense with which the defendant is charged, I now define certain terms and words. A person acts intentionally or with intent with respect to the nature of his conduct when it is the conscious objective or desire to cause the result. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Trevani Slaughter in Jefferson County, Texas, on or about the 12th day of February 2023, did then and there intentionally obstruct or prevent Heath Holmes, a person the defendant knew to be a peace officer, from effecting the arrest of the defendant by using force against said peace officer, to wit, by struggling with the arresting officer, you will find the defendant guilty, unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a person to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify or on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it in consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you believe they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of the charge is the verdict form. It's divided into two parts. We have a top and a bottom. The top part states, we the jury find the defendant not guilty as charged in the information of resisting arrest. And if that is your verdict, your foreperson will sign on this top line. Or the bottom states, we the jury find the defendant guilty as charged in the information of resisting arrest. And if that is your verdict, then your foreperson will sign on the bottom page. Does everyone understand? State, are you ready?
State's ready, Your Honor.
Okay, and defense, are you ready?
Yes, sir.
Okay, is 20 minutes enough for each side, or do we need more time? Okay, I'll be keeping the time. State, you have a right to open and close the argument. Mr. Masranian?
Your Honor, the state waives its right to open, but reserves its right to close.
Okay. Mr. Burbank?
Police court, counselors.
Yes.
Good afternoon, ladies and gentlemen. This has been a long, short trial. It has been one of the first that I've ever started trials at 1:30 in the afternoon. It's usually 8 o'clock, 8:30 in the morning and going until dark time. But that does not mean it's important, and I thank y'all very much for your patience. Because when I told you Monday afternoon in reference to this process, and some of you have already been through it. This is the only system in the country that allows the citizens to judge and render punishment if found guilty. And so I take that extremely serious, and I deeply thank you for your time. We do. One of the other things that I talked to you about Monday was that everybody has a right to a trial, and a citizen of this country has a right to be tried, of course, by its peers. And that is what Ronnie is doing. Now, you may scratch your head a little bit, and you may go, why? But if a person has a belief that he has not done anything wrong, or he did not cause something, and persists in that belief, then really the ultimate deciders is you, ladies and gentlemen, the jury. And I want you to take that into consideration. The other thing is that we talked about burden of proof and beyond a reasonable doubt. The state has the obligation and the burden to prove each and every element beyond a reasonable doubt. The other thing that you were told when you were sworn an oath to was that you were going to listen to the testimony from this witness. There really, well, there's two videos. That states different 1, 2, that you can go back and take a look at. But this charge tells you what the law is, and you must follow this charge because you've taken an oath to do that. Right? I've said, too, that in a trial, I usually try, and I did tell you, to let's put everything on the table and you all decide. Yeah, I still hold to that. But you're kind of unique in this situation because, well, and I guess not nowadays, when I first started, it's kind of hard to have, but nowadays, everything's videotaped. And so you have what happened. You have what happened at the scene, you have what happened at the hospital. The charge says that on the day in question, February 12th of 2023, and it's a little bit after this gentleman right here resisted arrest when Holmes, which is the second officer that testified, tried to arrest him. He found by it. It's in that charge. What I say is not evidence. And only my job and the state's job is to point out things that may say they have not proven their case beyond a reasonable doubt. If you go back to the scene, who was the individual that was talking to him? I'm talking about Terrence. That was Officer Frank. He was the one that came up, whether he was driving, not driving, intoxicated, not intoxicated, that's not the question here. We're here for resisting arrest. It's right there. Who placed the handcuffs on Cavani and said he's under arrest for the offense of DWI? Was it Holmes? It was Flanagan. Well, I question whether or not he ever did anything to resist or whatever, but we know he went to the car, he went over on top of the car, he pushed him over the cattle guard. In front of the car, people were yelling at him, police officers were yelling at him, and it's all in State's Exhibit number 1. And all you heard him saying was, what did I do? What did I do? Well, he was being arrested for DWI, okay, that's fine, but he's like, give me an explanation. And what did they do? They yelled at him. They told him, don't resist. I didn't see any resisting. He had his hands behind his back. Well, he's such a bad guy. Well, is he? Because you heard Officer Flanagan, thanks, gentlemen, okay, saying we had to take him to the hospital because it was an automobile accident. We couldn't checked out because before we go to town. And that's policy. Well, what does he do? Brings him to Baptist Hospital, and I guess he wasn't resisting, because I didn't see him resisting at the scene. And he really, I guess the focus of the state charge is not the resisting at the scene, but at the hospital. But they get to place the handcuffs from behind his back to the front of his back. Or, yeah, in the front of him. That's done. So that means he's fine. We know he was fine at the scene because he was cooperative, he was talking, he was answered all their questions. I guess at the hospital, he was doing the same thing. And then lo and behold, in State's Exhibit number 2, we see 4, 5, 6 officers on top of him in the hallway. Doing what? I don't have any idea. Well, maybe it was because he assaulted the nurse. That charge never went anywhere. So that assault might not have been good. But the question is, and what I want you to focus on is that the resisting, it appears to be, was at the hospital. You know, they went, and of course, officer safety, 3 tones, 10 officers there. Count them in the video. Did you ever hear Officer Holmes say, "You're under arrest"? He didn't. He didn't. Officer Flanagan told him at the scene he was under arrest. He was already under arrest. You can't be under arrest twice or 3 times, once. You're under arrest. You're going to county, wherever they're going to take you. So how can you resist arrest? And how can you resist arrest when it says in the information, the jury charge now, that Officer Holmes said you were under arrest? And remember his testimony. Not one time did he say I was trying to place him under arrest for reasons. He was already under arrest. The case is flawed. Good or bad? And I ask you to consider that. The other thing is that, and you could hear Officer Holmes, he wants to make sure that the testimony, and I'm sure he can find office, but he wants to make sure that whatever he's here to testify for, that they get what they want. Do you notice when I asked him questions about different things, he didn't even read the report prior to coming here, and he didn't never remembered. I did other things over the last 3 years, absolutely right, wrong. This is someone's freedom. But I heard him say, and I'm not evidence, and I'm not, what I say is just argument, but did you hear him say he didn't want his blood drawn? Did you hear him say that he was afraid, or thought he was afraid of needles? Well, I have never, and I'm not a doctor. Well, I guess I am a doctor in a way of jurisprudence, but not a medical doctor, but I have never had my blood pressure taken where they use needles. Never. And I've never come or gone to a hospital under his circumstances or seen where they automatically draw blood for blood sugar. Ridiculous. It's a prick at most. they don't draw a vial of blood. Why did he say that? Because I believe they were trying to get blood from him, because he had refused. But there's a problem. They're at they're at the hospital at 1:00, 1:30, and that warrant wasn't signed until 3:30 by the judge to take it. Would somebody have been upset? Absolutely. He refused. There is no legal precedent to take the blood from him. Another factor to this. As I said, it has been a long, fast trial, 2 witnesses. You actually have seen both sides because of the video. So he didn't testify, and you can't take that into consideration, but you know what happened, it's there. But I would ask you, when you take a look at this charge, and on page 1, and you're gonna get, when they said, and they state that he had intentionally obstructed or prevented Heath Holmes, person they knew to be a police officer, from effecting arrest. Go recollect whether or not he said, right here, Slaughter, I am placing you under arrest for resisting. He didn't do it. And there's no shame that if the state has not proven the case beyond a reasonable doubt, because that's what the system is based on, of not guilty, and let him get it right the next time. I thank you all very much for your time.
Mr. Marat, Attorney Maradian.
Is that okay? Ladies and gentlemen of the jury, this is a rather simple case. All that you are being asked to do at this point in time is, as Mr. Burbank has laid out, look at the law and look at the facts that have been presented by the state and apply those facts to the law. And all you'll need to do to reach a conclusion in this case is ask yourself one simple question. Does the evidence prove that the law of the state of Texas has been violated beyond a reasonable doubt? Now, you have the law in particular that we were discussing in the jury charge with you. It's all defined, it's all gonna be laid out, the judge just went through it. And since you'll have to break this apart element by element to see if we've proven our case beyond a reasonable doubt, I thought we might be able to do this together while I have you. So the first thing we need to decide, on or about February 12th, 2023. Heard from the officers, they responded to a call that night. You heard this happen in the early hours of this morning. It's been completely uncontested that these events took place on February 12th, 2023. So we have that beyond a reasonable doubt. In Jefferson County, you heard from the officers that this was, the call they responded to was on North 11th off of I-10. That's within Jefferson County, and our lovely Baptist Hospital, which again is in Jefferson County. So we again have another element beyond a reasonable doubt. The defendant, Mr. Slaughter, we heard from the officers that they identified him. They saw him as the same person that was there that night, and he's on video. So again, we have him beyond a reasonable doubt. I missed the word here, intentionally prevented or obstructed. Now, you heard directly from Officer Holmes that Mr. Slaughter's struggling with him at the hospital prevented or obstructed him from effecting that arrest. And I'll get to the arrest shortly, but you heard from him directly that it prevented or obstructed him committing the arrest. And you could also see for yourself how his movements, how his pulling away, how his fighting with them not only caused Officer Holmes to struggle preventing placing him under arrest, but a multitude of other officers had to get involved, help them as well. We have another element, beyond a reasonable doubt. A person the defendant knew to be a peace officer. They were all in their police uniforms. You saw them on camera in their police uniforms. You even hear him say, "Take me to jail." So he knows who he's dealing with. Not really a point of contention, that he knew that these were police officers. From effecting an arrest of the defendant. Now, Mr. Burbank went through a long spiel about how the person who placed Mr. Slaughter under arrest was actually Officer Flanagan, and he did it at the scene of the crime, or at the scene of the wreck, I should say. But there's a problem with that, and Mr. Holmes explained it when he testified. The arrest doesn't end when the handcuffs go on. If it did, as soon as the handcuffs go on, then what comes after that? Where does the arrest end? You heard from Officer Holmes directly say, the arrest ends when the person is brought to jail, released from the officer's custody, and turned over to the people at the jail. So it doesn't matter that Officer Holmes didn't tell Mr. Slaughter at the hospital, "You're under arrest." That's not required for there to be an arrest at any point in time. So understanding that, yes, while Officer Flanagan arrested him at the scene, Officer Flanagan arrested him for a DWI. He didn't charge him with resisting, and there was that slight or alleged, let's say, resisting at the scene of the crime where they brought him to the hood and they bent him over, and then you hear Officer Fell say, "Stop resisting," yada yada. But we can't really see anything. And to be honest with you, if that was the only resisting in the case, that would have been dismissed. That's a horrible resisting case. You can't see anything, you can't prove anything. That would have been dismissed. So for y'all's sake, for y'all's purposes, you can just disregard that. Disregard any resisting that happened allegedly at the scene of the wreck over the hood. What we care about is what happened at the hospital. It is the position of the state that the defendant was still under arrest at the hospital. They were required to bring him there. They needed to bring him there for a medical clearance by the hospital staff since he was involved in a wreck. And at that point in time, he was sitting there. We had him in the hallway, still under arrest, but they could not effect, or he was obstructed in completing that arrest by bringing him to the hospital by the defendant's actions when he struggled with him. So we believe we have that beyond a reasonable doubt. But again, it's up to you, the jury, to make that determination. And by using force against the peace officer. Now, I know you've seen this video. This will be your third time, and you'll be able to look at it again when you go back there. But I just think it really speaks for itself. That's not resisting. I don't know what is. And then you see him get calmed.
Relax, man.
I am
Talk
with
to me.
that.
Don't talk to them. Talk to me.
Man, I'm talking to you. I've been talking to you.
I know you have. Now relax.
And you know, Mr. Burbank brought up an interesting point. That at the scene of the wreck, Mr. Slaughter was rather calm. He didn't get violent. The only problem with when the arrest was about to happen was he kept walking away. Again, that would not be resisting. That would be more like evading. And they must have decided at some point he was calm enough to move his handcuffs from the back to the front. But what else did we talk about? What was left out by Mr. Burbank? And Mr. Slaughter was drinking that night. We discussed with Officer Holmes how people who are intoxicated have much more volatile mood swings. They can go from that 0 to 100 real quick. It may be Officer Flanagan made a judgment error, an error in his judgment when he decided to remove the handcuffs from the back of an intoxicated individual to the front simply because he had been calm for a period of time. What that led to was him having the opportunity to better resist the officers because something triggered him. Was never really fully decided whether it was an issue with the nurse, whether it was something else. Something triggered him to go from that 0 to 100. And that's what you see in this video. And again, he goes from what could be 0.
Did I tell you this?
Yes. Just, we sit in the chair. We'll be cool. We'll be cool.
Can you hear that? Take me to jail. Take me to jail. This is his intent, his conscious objective He is fully aware of what he's doing and what he's dealing with. There's no confusion here. He knows these are police officers. He knows he's being arrested. There's no confusion. It is his intent, his conscious objective to resist these police officers in this moment. For what? We don't know. No. Your receipt back to 0.
Nah, fuck that, that ain't no job.
Yeah, you got a 10 to 15.
Bring it to the county. Back it up, man, fuck that, nah, we ain't doing it. I don't wanna do nothing no more. Fuck that, fuck that.
You see him rising to about 40, 50 here.
Fuck it.
Hands up, Gil.
Man, fuck.
You get to about a 60.
Go get the round. Work, yeah, go get the fucking round. Fuck with that. No, play. But along, but I will get that thing with the stop, so mother on. It's there, guy.
Involved in the crowd, drive one block.
Man, I'm driving, no.
Calming back down, calming back down.
Still hands on me. I'm not exact.
So,
What you trying to do?
And here we go back to 100.
Oh. Ah.
Mr. Burbank talks about how there's 6 or 7 officers, 5, 6 officers, what have you, on top of him. I think they need to be on top of him in order to get some sort of control over him in that moment. And Mr. Burbank also brought up a point about how we don't know if his initial arrest was lawful. You know, he claims that he wasn't driving the car. We do have him on camera saying, I drove the car. Mr. Burbank was trying to allude to the fact that he was saying he's not going to take the SFTs because he's not going to drive. It's the state's position that Mr. Slaughter was saying that because he's not going to drive again. So he doesn't need to take SFTs because he's not going to drive home. He's not going to drive away from the scene. When asked directly if he drove that car, he said yes. Another point, the initial blood, if they were going to do a blood draw at the hospital. And at the time of the alleged unlawful blood draw, the warrant for the blood had not been signed by the judge. And so any blood drawn at that point of time would have been unlawful and would have been unable to be used in a court of law if the proper attorney made the motion to suppress the evidence, even if they found his blood alcohol content was a 0.3, you know, close to killing somebody of Mr. Slaughter's weight, a 0.3, and he was driving, got him dead to rights. So they took that blood unlawful. Wouldn't be allowed in court of law. So the reason we have in your jury charge telling you that the underlying arrest being unlawful, underlying search being unlawful, what have you, is no defense, is because the time to fight that is not in the streets, or in this case, in the hospital hallway. The time to fight that's in the court. We don't want to risk the safety of the individual, the safety of the officers, or the safety of the bystanders around them on that hospital floor to resolve an issue of an unlawful blood draw, supposedly. And it's not the state's position that there was going to be a blood draw that they were trying to check him out for violence. But if they were, that wouldn't have been the time to fight. The time to fight it is here in the courtroom, because that's how we do things in our civilized society. And Mr. Burbank talked about how in voir dire, people have different perspectives. Glass half full, glass half empty sort of thing. One person might see one thing another way, another person might see the same thing differently. And we're asking you to rely on the perspectives of the officers, and you are free to judge their credibility as you wish. But we also, again, have video backing up exactly what the officers told you. And that video is, as I discussed in voir dire, that sort of grade A evidence being above for beyond a reasonable doubt that we would want to bring you and that y'all said y'all would want to see to decide an issue beyond a reasonable doubt. And when you make your decision, remember you'll have that grade A evidence to make your determination, because you'll be able to review it all the same. And lastly, Mr. Burbank mentioned freedom. And he mentioned liberty, a person's liberty being at stake here. And during Bordire, he mentioned freedom just now in closing. I want y'all to understand something. The decision you are about to make has no impact, no direct impact on Mr. Slaughter's liberty, on Mr. Slaughter's freedom. Now you may be thinking, whoa, I may convict them, I may vote guilty, or I may vote not guilty. Doesn't that have any sort of impact? Even if you decide, all of you unanimously decide guilty, the range of punishment in this case includes a fine. Y'all can decide guilty, and whoever assesses punishment can say, well, let's give him a fine of $1. And his liberty is never guaranteed to be at stake. So I want you to solely focus on the two important things: the law and Mr. Slaughter's actions. And did Mr. Slaughter's actions violate that law? Yes or no? Two things that I'm asking y'all to do. Thank you for your time, and I'm sure you'll have everything you need to make the right decision.
Okay.
Yeah.
Okay, ladies and gentlemen of the jury, the closing arguments have been completed by both the state and the defense. Before I give you the charge to go back into the jury room with you, I need to inform you that you noticed that I told you earlier, we usually have, there's 6 on a case, 6 jurors. You notice you're 7. So that just simply means that one person is the alternate. And the person that is the alternate, juror number 12, Jared Lee Laurie Meyer. Okay? So Mr. Lorimeyer, you will not be allowed to go back into the jury room with the other 6 jurors. If something happens and one of the jurors is not able to complete deliberation, then at that time you will go into the room to deliberate along with them. So at this time, we'll ask Ms. Lorimeyer, you can have a seat in the courtroom, or you can have a seat in the hall. Once the jury exit the jury room, exit the courtroom. Ms. Bailey, this is a charge, and remaining jurors can follow the bailiff into the jury room. Everyone, please stand. Court will be in recess till the jury comes back with a verdict. put, oh, hold on, you can't put up the number. Mhm. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 23 CCCR 0951. The case is filed the state of Texas versus Trevani Slaughter. Let the record reflect that Mr. Slaughter is present in court with his attorney, Attorney Tom Burbank. The state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, and Attorney Samuel Masradian. I've received a message from the jury that it has reached a verdict. Will the bailiff please bring the jury into the courtroom? Everyone in the audience, please stand.
Oh no, let's see. Yes.
You may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present and seated in the courtroom. Full person, have you reached a verdict in this case?
You have your honor?
Okay. Is the verdict unanimous? That is one that is agreed upon by all members of the jury.
Yes, sir, it is.
Please hand the verdict and to, okay. Okay. Now, full person, is the verdict the unanimous verdict of all members of the jury?
Yes, sir.
Okay. And in cause number 23 CCCR 0951, State of Texas versus Trevani Slaughter, we, the jury, find the defendant guilty as charged in the information of resisting arrest. You may be seated. Would anyone like to have the jury polled?
Not the bench, Judge.
State? Okay. Okay, members of the jury, I'd like to thank you for your time that you spent with us these past 3 days. And I know that during your service as a juror, you paid a great deal of attention to all the evidence that was presented in this case. And so on behalf of the citizens of Jefferson County, behalf of the staff here in County Court at Law number 2, I'd like to thank you for the time and attention that you have paid in this particular case. Now, your jury service is complete. Now, since your service is complete, we need everyone to just return those badges. Our district the clerk's office is still open. So if you need excuses, then the district clerk's office will be able to provide you with any excuse that you need. If they are not able to provide you with those excuses, you can come back here and we will have our court administrator, our court coordinator to provide you with the excuse that you need. Now, as I mentioned to you, at least to the other members of the panel on Monday, anytime that you're in the area of County Court at Law number 2, you can come and have a seat in your courtroom. And as I mentioned, that area back there, that's the area you'll be permitted to sit in. We call that the peanut gallery, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and just see what goes on. And I know that you will find it to be very interesting. Now, normally I give handshakes, but as I mentioned to the other members of the panel, we still have COVID in our community. However, I like to give each and every one of you an air handshake. And thank you for being here. Thank you for all of the time and attention that you have given to this particular case. Now, the lawyers may want to talk to you after you exit the courtroom. You can talk to them if you would like to, but you do not have to talk to them if you do not want to. Okay? So again, ladies and gentlemen, jury, thank you for all of the hard work that you have put into this case. And our court bailiff, she has some letters that she's going to give to each and every one of you. You are excused, and each and every one of you have a blessed day. And just a reminder, just a note, in this case, the defense did not file a motion for the jury to do the punishment. And so the court will be doing the punishment. Let me ask you, y'all can have a seat. Let me ask this question. Now, what I can do, actually, if you're ready, I can do punishment today. Okay? And so I can, Mr. Burbank?
Yes, sir.
I'm gonna do punishment
Yeah.
today.
Yes, sir.
And is there any agreement that either party, do the parties have, y'all have an agreement as to punishment or not? If you do not have an agreement, then I will just, okay. Now, at this point, State, what is your, now, do you have an argument for punishment?
Yes, Your Honor.
Okay,
Your Honor, since the jury found the defendant guilty of resisting arrest, the state asked you to consider the reality of the evidence presented, that the defendant did not simply pull away from the officers, that they actively struggled with the officers, even so as far as to injure one of the officers' hands in the handcuffs. Additionally, the defendant struggled so violently that they had to subdue him in a wrap to make him able to be handled. Just for the blatant disregard of the law and for the safety of our law enforcement community, we ask that this would warrant serious consequences, and the state asks that the court sentence the defendant to 90 days in county jail, probated over 15 months,
15 months.
assess a $500 fine, and require the defendant to perform 40 hours of community service as part of the conditions of any probated sentence. Alternately, the state would ask for the defendant to serve no less than 30 days in county jail, and this punishment properly reflects the gravity.
Mr. Burbank?
I'd like to call Mr. Slaughter.
Okay, Mr. Slaughter, would you come on up? I can swear him in. Mr. Slaughter, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Slaughter, you may put your hand down. You like to do it from the witness?
I can do it right
here. Right here.
if you like.
All right.
For the record, could you state your name, please?
Giovanni Sullivan.
Ms. Slaughter, you heard the recommendation of the state, either to place you on probation for 15 months and subject you to 90 days in jail if you violate that probation, or to a term of county jail, which was again
No,
30.
30 days.
30 days? Okay, you've heard that, right?
Right.
Let me ask you some questions. Are you working? Right, do you have a family to support?
Yes, sir.
And how many kids do you have?
7 biological and 4 step,
Okay,
And how old are they?
21, 17, 16, 13, 7, no, 8, 3. There's a lot.
Okay. How do you support them if you're not working?
Well, since I've been dealing with this for 1,066 days, kind of been off work, dealing with this, trying to get this out the way, get this resolved, but
So when you're given the option of either probation
Mhm.
or jail time, what would you like to take?
What's the probation again?
Probation is for 15 months, which is a year and 3 months,
Jail time?
30 days.
Give me 30 days.
You would ask you, the court, to consider giving him 30 days.
okay. Now, Mr. Slaughter, well, Mr.
We rest.
Burbank,
We rest.
okay. Can I ask him some questions?
Absolutely. Your Honor.
Okay, now, Mr. Slaughter, you stated that, I'm looking at your, an affidavit of indigence that you had, that's in your file. This was done back in 24. You said you've been out of work for some time.
Yes, sir.
How long have you been out of work?
2.5 years now.
Okay. And so you have no source of income?
Not at the moment.
Okay. Criminal history.
You
The-
may ask him, Judge.
Yes, you have a criminal history in this? Yeah, it's your first.
First,
Okay, now that makes you see, are you saying that you want to do jail time because you don't think you can pay the fine and court costs? Is that what it is?
but not that is that, I'm a commercial driver and I drive over the road. Certain times, I can't come back, due to the weather, traffic, what's going on, so. just
Okay,
ready
but
to get over it.
but you're not working now.
No, I'm not working now, so I just better get it out the way, that way I can get back to work.
Okay. Okay. Mr. Burbank, you have anything else?
No, Judge, I mean, you're not bound by 30 days.
Right,
So if the court would consider less due to his lack of criminal history, his age. I guess I didn't ask that. How old are you?
38.
38 years old, almost 40 years old, with a lack of criminal history. He does have a number of dependents. So, and you've seen what happened, Judge. It's not right, but
okay. Now this, the punishment range, as you're aware, Mr. Burbank and Ms. Nixon and Mr. Maserati, the punishment range for a Class A misdemeanor is minimum 0 days to maximum 365 days, which is a year in the county jail. Okay, so or you could be given a fine that does not exceed $4,000. Or you could be given both such fine and confinement. Okay, now the court is also reflecting on the fact that, the facts of the case, as well as, your criminal history. I do know that you stated that you do not work, which will be a little, well, I mean, but there are some things that even if he's placed on probation, by law pursuant to Article 42.15 of the Texas Code of Criminal Procedure, if a person, is indigent, and the court has previously found him to be indigent, and apparently he's still indigent, the court can, either, for example, with the fine, the court can convert fines and court costs to community service. The court can also, waive, certain things like, attorney's fees pursuant to Article 26.05 G-1 of the Texas Code of Criminal Procedure. The court can waive reimbursement fees, which is a $15 fee pursuant to Article 102.018 of the Texas Code of Criminal Procedure. The court can even reduce, probation fees to, the statutory minimum of $25, or in the event that the person is totally unable to pay, the court can waive it. I think that's pursuant to Article, is it I forgot, I think it's 362. But the court, there are some things that the court can do, regarding, your inability to pay in this case. The court is also considering, the facts of this case. And when I say, yes,
Mr. Slaughter stated that he didn't have, any other convictions. He had a conviction for wrongful fictitious altered obscured vehicle plates and registration in 2000. The offense date was in 2007.
2007, you recall that?
Yeah, we got it.
No, what is it called? What was the offense?
It's a wrong fictional altered obscured vehicle plates registration. Is Class B misdemeanor.
Was a traffic ticket for somebody else's license plates on the vehicle?
Now someone stole my sticker.
Somebody stole.
Oh,
the sticker.
so you had the wrong sticker on your vehicle?
Yeah.
Is that what it was? Okay.
That's a traffic.
And what was the punishment in that case?
It's a Class C judge.
6 months probation.
Class B, Your Honor.
It was a Class B. You had what?
6 months probation.
Okay, now did you complete the probation?
Yes, sir.
Okay. Now, as I mentioned to you earlier, in terms of probation fees pursuant to Article 42.8.652, Section B, if the court determines that payment of these fees, the reimbursement fees will cause you to have a significant financial hardship, they can be waived. Okay, so what I'm suggesting to you and what I'm telling you is that there are things that are in the code that allows the court to make adjustments. And it's something that's your attorney could tell you this here. Something that's called equal protection of the law.
Okay.
In essence, you might have a rich person, a poor person, and so they kind of balance it off. Things that you can't pay, things that the rich person can pay. It wouldn't be a hardship to them, but it'd be a hardship to you. And so there are provisions that the legislature have put in the Texas Code of Criminal Procedure to balance things out. For a person who can pay, for a person who cannot pay. Okay. So now state, your position is you're asking for 90 days, Jefferson County Jail to be probated for 15 months, right? And a $500 fine plus court costs, 40 hours of community service. Is that correct?
Yes, Your Honor.
Or in the alternative, 30 days jail.
Yes, Your Honor.
Okay. And Mr. Burbank, He's,
Right, Judge.
okay, he's asking for, he'd rather take the 30 days in jail, is that correct?
Yes.
Okay? Um. Let me do this, I need to have y'all come up. Okay, so at this time, the court is gonna assess punishment at 30 days in the Jefferson County Jail. Okay, now, state, we can, does he really go into custody today? Okay. So your punishment will be assessed at 30 days in jail.
You have the certificate.
Yes, I have this here. I have before me trial court certification of defendant's right of appeal. Now, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
Before you signed this document, did your attorney go over this document with you?
Yes.
Did you understand everything in this document?
Yes.
And is everything in this document true and correct to the best of your knowledge? Okay. All right. So, Mr. Slaughter, just have a seat. We have to draft up the paperwork. And then once you finish the paperwork, you'll follow the bailiff into the back. All right.
And just for the record, Judge, because this was a jury trial, he does have a right to appeal for.
Yes, that's in here.
Thank you.
Okay. All right. Okay, ladies and gentlemen, jury, this will conclude your services. You're free to go. Like I said, if the lawyers may want to ask you some questions, if they want to ask you questions, you can answer them. If you do not want to answer the questions, you do not have to. Thank y'all very much, and y'all have a blessed day.
Nice meeting a lot of people.